On August 24, 2023, the U.S. Sentencing Commission voted to make two important amendments to the U.S. sentencing guidelines retroactive, namely Amendment 821, Part A and Part B. Today we will step through Amendment B, a new Chapter 4 guideline at 4C1.1, also known as the Adjustment for Certain Zero-Point Offenders. This amendment affects defendants and inmates who have zero criminal history points. The Commission estimates that nearly 7,300 inmates qualify for potential reductions under this amendment, which has an effective date of November 1, 2023. There are two categories of inmates considered zero-point offenders. A. Defendants with no prior convictions. B. Defendants whose convictions fall outside the time limits in Section 4A1.2 D and E of the sentencing guidelines, or whose prior convictions were otherwise excluded from their criminal history calculation. Passing this initial eligibility test, the defendant must then meet these 9 requirements that are outlined in the amendment. No terrorism adjustment under 3A1.4. No use of violence or credible threats of violence in connection with the offense. No death or serious bodily injury caused by the offense. Not a sex offense. Defendant did not cause substantial financial hardship. No use or possession of firearm or other dangerous weapon in connection with the offense. No civil rights offense under 2H1.1. Did not receive an adjustment for a hate crime, vulnerable victim, or a serious human rights offense. The defendant did not receive an aggravating role adjustment while engaged in a continuing criminal enterprise. If all criteria are satisfied and the defendant has yet to be sentenced, they likely qualify for a 2-level reduction to their offense level, resulting in a lower guideline sentence range. For those already serving a sentence, we check if they received a downward departure or variance at their original sentencing. If so, we compare their imposed sentence to the amended guideline range. If the sentence imposed is lower, they likely do not qualify, although exceptions exist where a judge may consider further departure. These rare cases require technical analysis to assess. If it is not lower, they likely qualify for a 2-offense level reduction. At this stage, eligible defendants may file a motion for resentencing under 18 U.S.C. 3582C. Utilizing relevant sentencing statistics and data can be critical to securing a reduced sentence from the court. The judge will most likely rule on these motions without a hearing, simply reviewing the original sentence and resentencing materials. While reductions are not guaranteed, the judge must consider the 18 U.S.C. 355A sentencing factors when making their determination. Please note, there may be additional factors such as mandatory minimums which may disqualify a defendant. If the defendant received a 5K1.1 departure below the amended guideline range, he or she may still qualify for further reduction. The Commission projects average sentence reduction of 11.7%. Average sentence may drop from 85 months to 70 months. We hope this helped you understand the zero-point offender amendment a bit better. As you can see, federal sentencing is complicated. The path to resentencing under the guideline amendment starts with data and analysis. Sentencing Stats is offering a free pre-qualification tool, a resentencing calculator, and a sentencing data eligibility assessment. We recommend you visit zeropointoffender.com or SentencingStats.com /Amendments 821 to get assessed.